In Barry v Essex County Council, Deputy District Judge Rathod determined the proper method for calculating enhanced interest on costs under Rule 36.17, paragraph 4c, after the claimant beat her own Part 36 offer. The claimant had succeeded at trial and, under District Judge Mills's order, was awarded indemnity costs from the offer's expiry, with interest at 9% per annum. The issue was whether interest should be applied to the aggregate of all post-offer costs from the expiry date, or calculated item by item from the date each cost was incurred. The court held that the aggregate method applied. McPhilemy v Times Newspapers Ltd was not binding on this point, its compensatory rationale having been treated as limited following OMV Petrom SA v Glencore International AG, which recognised the non-compensatory element of Part 36 enhancements. The aggregate method was consistent with the broad brush approach endorsed in Simcoe v Jacuzzi UK Group plc, reflected the post-Jackson settlement policy underpinning Part 36, and was the only workable method, particularly in cases involving summary assessment. Quote, "I consider that in such a case, the individual item method is not workable at all, which rather demonstrates, in my view, that it is not the correct method to be used to calculate interest under Rule 36.17, paragraph 4c. Indeed, in my experience, it is the aggregate costs method that is used when calculating enhanced interest on costs where a claimant has beaten their own Part 36 offer in a fast-track trial, and where the court is required to conduct a summary assessment of costs. For those reasons, I find that the aggregate costs method contended for by the claimant is the method which is consistent with authority, with the policy behind Part 36, and with the practical reality of calculating awards of enhanced interest on post-expiry costs.
For a detailed summary of this decision, visit tmclegal.co.uk.